This courtroom hearing starts like a routine case over minor traffic violations, but it quickly spirals into a tense and unforgettable confrontation. From the very first moments, the judge is forced to repeatedly order the defendant to sit down and stop interrupting the proceedings. Instead of cooperating, the woman launches into a stream of familiar, sovereign citizen rhetoric, refusing to recognize the court's authority and insisting she is not the person being charged. As the judge calmly lays out the facts, it becomes clear that the charges are relatively minor: driving without a license and expired plates, offenses that carry small fines and no jail time. But logic and legal reality do nothing to slow the defendant down. She claims to be an authorized agent, speaks of estates and trustees, and attempts to surrender the person to the court as if this were some kind of contract negotiation rather than a legal hearing. The tension rises when she demands a jury trial, confidently asserting constitutional rights that don't apply to her situation. The judge explains, clearly and patiently, that because there is no risk of jail time, a jury trial is not guaranteed. That explanation, however, only fuels more arguments, interruptions, and defiance. Eventually, the judge's patience reaches its limit. With the courtroom's authority on the line, the judge issues a firm ultimatum. Comply with the court's instructions and obtain a trial date, or be taken into custody for contempt of court, immediately. Faced with the reality of arrest, the defendant finally backs down, bringing this heated courtroom standoff to an abrupt and telling end. This is a powerful example of what happens when courtroom myths collide with real-world law.
Ma'am?
I'm sorry. I'm just trying to get my stuff situated so it's ready here.
Take a seat
I have a question.
in this blue chair.
Do I have
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit down.
rights there?
One more time. Sit down. Now you'll answer my questions. Got it? Did you understand all of the rights and plea options that I explained to you?
No, I do not understand.
Okay. Then I will enter no plea to the charges filed against you. Well, let me just explain to you. You are charged, and I do have a signature on the citation which shows you've been served. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs. I will enter no plea to these charges against you. You already have a pending. You already have a pending.
I object.
What do you object, ma'am?
Because I did not enter that plea.
Okay, so you tell me how you would like to plead: guilty, not guilty, or no contest.
First, I have to correct the standing, which is I am not the ens legis non begeer. I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case. I have sent in a paper that is my declaration and affidavit of what I want to do, which is to settle the case. I am willing to surrender the person to the court for mutual consideration. I do not want to continue doing this. I don't have anything to do with this. That paper that I signed, which is the summons, is signed v coatis, which is void contract, and I reserved all of my rights on there. So, is the court willing to give me mutual consideration today or not?
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead
No,
What you've
I do
just-
not recognize
Well,
anyone in this court.
Okay, well,
I
that's
don't
too bad.
recognize you or the bailiff or anybody else in this court. I do not understand.
I will set this case for a bench trial, and
No,
we'll get this set.
I have the right to a trial by jury.
Okay, no you don't, not in this case.
Yes.
Now, these are not jailable offenses, ma'am. You don't have a right to a trial by jury in this case. You already have a jury trial scheduled in another case, but then because you're facing jail time in that case. But in this case, you're not facing jail time, only a fine and court costs.
Anything that is above $25 in a court of law has the right to a jury by trial, which is involuntary. Can't be violated, basically, is what it means. So I have the right to a jury of my peers.
No, you don't.
Yeah.
We're going to set it for trial, and you're going to go to the clerk's window, and they'll give you a trial date. Okay? So,
Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis non de guerre. I
Yeah,
told you that.
I don't know what that means either, ma'am. I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So,
great.
yeah.
So
Ma'am, if you don't leave the courtroom, and if you don't go to the clerk's window to get a trial date, I'll have you arrested and hold you in contempt of court.
With what contract?
There is no contract.
I know there's
You're looking at the contract. You're looking at the one who's going to be able to, has the authority to be able to put you in jail and I'll hold you in contempt. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested.
So, contempt of court for what? What contempt?
For not doing what I'm telling you to do, which is to go to the clerk's window and to get a trial date.
You're the trustee and I'm the beneficiary.
No, there is no trust relationship here.
No, there isn't.
I've drafted many trusts, and there is no trust relationship between the judge and you, the defendant.
Yeah, because
You are not the beneficiary, and nor am I the trustee.
Yes.
Yeah, that's just not how it works, man.
It
Not
is.
how it works. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Is this your phone?
What begins as a routine courtroom hearing quickly turns into a tense and uncomfortable confrontation that shows just how far some people are willing to go to deny reality. The judge takes the bench expecting a simple case involving minor traffic violations, the kind that are usually resolved in minutes. Instead, the courtroom is immediately disrupted by a defendant who refuses to follow even the most basic instructions. From the very start, the judge repeatedly tells the woman to sit down. She refuses. She talks over the judge, interrupts the court, and insists on controlling the conversation. The judge remains calm but firm, making it clear that the courtroom is not a place for arguments or performances. Orders are given. Warnings are issued. None of it seems to matter. The judge eventually lays out why the woman is there. She is charged with driving without a valid license and operating a vehicle with expired registration. These are minor misdemeanors. There is no threat of jail time. The penalties involved are limited to small fines. This should have been one of the easiest hearings of the day. But instead of acknowledging the charges, the defendant launches into a rehearsed speech filled with familiar phrases commonly used by so-called sovereign citizens. She insists she is not the person named in the case. She claims to be an authorized agent, acting on behalf of a decedent estate. She speaks as though the court is a business transaction and not a legal proceeding. The judge listens, then explains clearly and patiently that none of these claims have any legal meaning. The court deals with real people, not fictional legal constructs. The woman standing in front of the judge is the same person who was stopped by law enforcement, cited, and summoned to court. No amount of wordplay changes that fact. The defendant refuses to accept this. She continues to interrupt, repeating phrases about trustees, beneficiaries, and surrendering the person for mutual consideration. Each statement drifts further from reality. The judge pushes back, stating plainly that these arguments are nonsensical and have been rejected by courts across the country countless times. As the hearing continues, the woman demands a jury trial, speaking with absolute confidence as though invoking the Constitution automatically grants her what she wants. The judge corrects her again, explaining that the right to a jury trial applies only when jail time is a possibility. Because these charges carry no incarceration, a jury trial is not required. The law is clear, and the explanation is direct. That explanation does nothing to calm the situation. The defendant grows more defiant. She refuses to answer simple questions. She refuses to follow basic instructions. She challenges the authority of the court at every opportunity. The judge's tone changes, becoming sharper, more controlled, and unmistakably serious. The judge warns her that continued disruption will result in contempt of court. This is not a theoretical threat. Contempt carries real consequences, including immediate arrest. The judge explains that the courtroom cannot function if individuals are allowed to ignore orders and derail proceedings. Still, the defendant presses on. She insists she is appearing by special appearance only. She claims the court lacks jurisdiction. She argues that she does not consent to the process. The judge responds bluntly, stating that consent is not required. Jurisdiction is established by law, not by personal belief. At this point, the courtroom grows quiet. The judge has reached the limit of patience. The message is no longer instructional, it is final. The defendant is given a clear choice. She can comply with the court's instructions, go to the clerk's window, and receive her trial date like every other defendant. Or she can continue to argue and be taken into custody immediately for contempt. For the first time, the reality of the situation sets in. The threat of arrest is no longer abstract. Deputies stand ready. The authority of the court is unmistakable. The woman hesitates. Her arguments slow. The rehearsed phrases stop flowing as easily. After several tense moments, she finally complies. Without another speech, she moves toward the clerk's window as instructed. The confrontation ends not with a legal victory or a constitutional revelation, but with quiet submission to the very authority she spent the entire hearing denying. This courtroom encounter serves as a powerful reminder that no matter how confidently misinformation is repeated, it does not override the law. Courts operate on statutes, precedent, and procedure, not internet theories or semantic tricks. When beliefs collide with reality, reality wins every time.